Good day to everyone. For today, we will be discussing about original registration application. We will cover what indeed is original land registration, who can apply from this registration, where could they apply, what are the basic requirements, and other random question relating to original land registration. So what is a original land registration? Original land registration is an issuance by the Register of Deeds providing an original certificate of title to a person who owns a land. So mao ni siya ang original land registration. So who can apply in this application? Upon applying for this registration, those who by themselves or through their predecessor in interest have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands of public domain under a bona fide claim of ownership since June 12, 1945 or earlier. Those who have acquired land ownership of private lands may prescription under the provision of existing laws. Where could they apply? The application for land registration shall be filed with the court or first instance of the province or city where the land is situated. The application shall file together with the application of all original monuments or titles or copies thereof and a survey plan of the land approved by the Bureau of Lands. So what are the basic requirements? So we have 13 basic requirements. In terms of basic requirements, it must follow the procedure in which number 1, so we have survey of land by the Land Management Bureau or a duly licensed private surveyor. So mangita ka sa the Land Management Bureau or sa licensed private surveyor. So ngita pod ka og surveyor. And number 2, filing of application for registration by the application at the RTC or the province, city or municipality where property is situated. And number 3, setting of date for the initial hearing by the court, which shall not be earlier than 45 days nor later than 90 days from the date of the order. Number 4, transmittal of application and date of initial hearing together with all documents. So tanan nga documents or other evidence attached there to by the clerk of court to be the land registration authority. Number 5, publication of the notice of filing of application and date and place of hearing once in the official gazette and once in the newspaper or general circulation in the Philippines. Number 6, service by mailing or notice upon contiguous own occupant and those known to have interest in the property and posting by the sheriff of such notice in a conspicuous place at the land and in the bulletin board of the municipal building where the land is situated. Number 7, filing of answer or opposition to the application by any person with their name in the notice or not. And number 8, hearing of their case by the court. And number 9, promulgation of judgment by the court. Number 10, issuance of decree or order by the court declaring the decision, filing and instructing the land registration authority to issue decree of confirmation and registration. Number 11, entry of decree in the land registration authority. Number 12, sending of copy of the decree to the corresponding register of deeds. And last, number 13, transcriptions of the decree in the registration book an issue of the owner's duplicate original certificate of title of the applicant by the Register of Deeds upon payment of prescribed fees. If the land to be applied does not have approved survey, where to go? So asa ta moadto og wala siya approved survey, so moadto ta sa LRA or the Land Registration Authority. Land Registration Authority is mandated to issue decree or registration and certificates of title and registered documents, patents, and others for the benefit of landowners, agrarian reform, beneficiaries, and the registering public general to provide a secure, stable, and trustworthy record of the land ownership and registered interest therein so as to promote social and economic well-being and contribute to national development. So, ang usapod, ang kaniyang Land Registration Authority is committed to effectively implement the laws and regulations related to the registration of the land titles and deeds, to maintain and foster greater public trust and confidence in the torrent system through honest, prompt, and efficient service, and to preserve and maintain the integrity of the land records, to provide vital, accurate, and timely land-related information, as well as providing convenient working conditions and adequate incentives to all land registration personnel. What are the process of juridical original land registration? So we have 9 process of juridical original land registration. So first, file to annotation of the affidavit of loss. Number 2, request a certificate true copy with annotation of loss. Number 3, while a petition at the regional trial court. Number 4, attend the jurisdiction hearing. Number 5, submit proof of evidence. Number 6, wait for the issuance of a court decision. Number 7, wait for the certificate of finality to be issued. Number 8, file a court decision and certificate of finality and the Register of Deeds. And last, number 9, wait for the issue of replacement of owner land title. What is decree? So a decree or decree of registration is a document prepared and issued by the land registration in favor of the clear entitled person applicant upon the order of the court. It is another evidence of ownership. So mauni siya is a documents prepared and issued by the Land Registration Authority. So what is OCT? So OCT stands for Original Certificate of Title. So Original Certificate of Title is a true copy of the decree of registration. It is the original official certificate of ownership issued by the Land Registry of Deeds, naming, declaring, and attesting to the fact that the person named is the owner of the real property described therein, subject to such liens and encumbrances and thereon noted or the law, warrants, or service. It is the best proof of ownership of a piece of land, encumbrances as thereon. And that's all. Thank you.